Okay, you're watching this because I've sent you a link about filing for ex parte custody here in Alabama. My name's Sam Bone, and I'm going to go over the steps of what we need to do for file for emergency custody. And when I say emergency custody, that doesn't necessarily just mean emergency custody. That could be setting visitation. It could be stopping a child from being enrolled in a school. It means emergency, getting something done without the other party having an opportunity to respond. So here's the legal definition: is legal process granting immediate temporary custody of a child. Again, we're talking about just temporary custody. It could be other type things without the other parent having an opportunity to respond via hearing. This is used in emergency situations, and this is the key. This is the word that we're going to have to use, which is when the child is at risk of immediate and irreparable harm. And it's governed by Rule 65 of the Alabama Rules of Civil Procedure. I'm going to show you that real quick. So this is the law here. Rule 65B. Temporary restraining order would be emergency custody, may be granted only if it appears from specific facts. Okay, specific facts is key. Shown by affidavit, which means it's got to be under oath, or verified complaint. Again, under oath, that immediate and irreparable injury, loss, or damage. So irreparable. It doesn't just mean that like bad things are happening. It means that like it's going to happen right now, and if we don't do it right now, then the child could be injured, and we don't even have time to have a quick hearing. It's got to be done right now. And next, the attorney, me, would have to write out why I haven't gone ahead and given notice. So that's what the law says right there. Again, here's the law here: specific facts via affidavit. The key is, more than anything, it's got to be immediate and irreparable harm. And the reason I want to go over the law with you, number one, is to show when you're filling out this online form, why it's important to give as much detail as possible. Okay. So focus is the detail. We got to detail the reasons for seeking emergency custody and describe any immediate and irreparable harm to the child. That's key. So you're going to fill out this form. After you get it done, I need you to text us at this number or email us at this number. Here is the form here. You'll look at the style of your case, which if it's Smith v. Smith, you'll put Joe Smith versus Kayla Smith. You'll look at your previous document that you've already done. You'll look at the top of your previous divorce papers or custody papers, whatever it may be. Look, circuit, district, juvenile, just copy that. The name of the petition is, you'll put motion for emergency custody if you're trying to get custody, or motion to stop visitation, or put emergency motion and put what you're trying to get done. If it's a stop visitation because you've already got custody, or if you're trying to put them on supervised visits right now, that's what you'll put. The rest of the stuff's pretty self-explanatory. I need you to make sure that you're filling out all these things with correct grammar, punctuation, spelling, so that I'm not having to spend time to fix that stuff for you. Here's the key: immediate and irreparable harm, right here. So you'll say, it doesn't mean, if it just says mom's on drugs, that the court has no proof that the mom is on drugs. You'll have to put the mom is acting erratic and she's on drugs. The reason we believe she's on drugs is because we have this text message here where she says to her boyfriend, go get me another eighth. And then documents attached here too: the screenshot between her and her boyfriend, or the drug test where she failed at her job at the chicken plant. Here, immediate and irreparable harm from the attorney and court's perspective. So this is, you're going to pretend like you're the judge and put in your order why the mother shouldn't have custody. It would say, because it appears the mother has a drug problem. There's a picture of her with cocaine, something like that, just based on your case. Again, I can always clean this stuff up, but again, it's not, I can't have conclusory statements like the mom's abusing the child. Okay, we've got to have proof of that. So you got to say the mom is abusing the child. The school counselor contacted DHR. DHR came to the house. DHR then investigated and found that the child had bruising. I've got to have as much detail as possible, because the judge doesn't know what's going on in your life. We've got to let them know. So that's what we do there. Next, prepare for fees. If we're modifying custody, the fee in Etowah County is $308.88. I don't know what it is in other counties. And then you're going to have an attorney fee. I don't know what your attorney fee is. On your case, we'll have to talk in person, text, phone, to kind of figure out. Every case is different. Get me the documents. So if we need to show the court screenshots, school records, pictures, videos that are relevant to your case, I got to have those ahead of time. I've got to attach that to the emergency custody thing. You got to understand there's a difference in the amount of proof I have to get emergency custody versus just custody at a hearing. Custody at a hearing is, this is the better thing that should happen to this child. But custody right now, the other party doesn't even have a chance to respond. And so we've got to present such overwhelming evidence that the court feels there's no choice but to grant it. Next, after you fill that out, you need to come in. We'll be texting with you about when to come in to review and sign these forms. We'll serve the forms once you come in and sign it. We'll file it with the court. The court will then serve the other party. But in order to do that, I've got to make sure I have a good address. If we don't have an address to get the other party, then we just have to. We can't file it without giving them notice. Next, there'll be a court hearing. Once they're served, there will quickly be a court hearing. It's supposed to be within 48 hours. It doesn't always happen that way, but it's normally within a few weeks.